SJC-12216, Commonwealth versus Hobbs.
Ms. Caddick, good morning.
Good morning, Chief Justice Gantz. May it please the court, Elizabeth Caddick for Keith Hobbs. In this case, Demetrius Blocker was shot and killed at around 4:15 p.m. on December 16, 2010. Nonetheless, the Commonwealth obtained 3.5 months worth of cell site location information from December 1st to March 15th, 2011. The issue was preserved with a pretrial motion to suppress evidence based on failure for there to be probable cause for the 3.5 months worth of the CSLI. The motion judge found that there was probable cause, mainly based on the fact that the defendant had not yet been apprehended, and said that the 3 months after the crime, the CSLI was necessary in order to determine where he was. Of course, this is an error of law. There is no probable cause for those 3 months, either to determine evidence of the crime, to determine whether Keith Hobbs was guilty of that crime, or to apprehend Keith Hobbs. This was not prospective GPS tracking, which itself requires probable cause and which only allows for 15 days worth of prospective GPS tracking.
So there was certainly probable cause to believe that he had been involved in the killing.
There was in the affidavit where the affiant had stated that Keith Hobbs' brother had called the police and said, "I saw him on the surveillance video, and that's my brother Keith Hobbs." So there's no question that there wasn't probable cause for a period of time during the crime.
And there arguably would be probable cause for some period before and after to see whether or not this individual just was there all the time, or whether he had gone to that location for a purpose, since there was a claim of premeditation.
Well, I would say for a very short period of time there would be probable cause, but because this is an area where people can go by on the T, various Ts and buses, that they might set off the cell towers along that route, maybe once every month, depending on if they're on their phone at the time they pass.
So apprehension was too late, right? Because the time period requested was many months after.
It was, and in fact,
So would you agree, though, that if a crime occurred and Augustine allows for apprehension, and the person is in the wind for a month or so, the police could look for that to find out where the person is? But here you think it was so stale.
Right. In Augustine, they wanted to know whether the defendant was near where the body may have been dumped in the river sometime after. So they wanted to know, was he around where they thought the crime scene was, and was he around where they...
But apprehension is, I think, broader than that, right? Because apprehension would show where a person hangs out with their, so for a certain time period. But in your view, it was too late for that.
Right, and also as another example of how this really wasn't for apprehension, the affidavit was signed on March 17th, asking for cell site location information up to March 15th. It wasn't signed by the court until, I believe it was the 24th.
Can you give me those dates again, please?
Yes.
So the crime occurred on what date?
December 16th, 2010.
Okay, and then
And the application for the CSLI was April 17th, 2011. It was March. Did I say April? I said March 17th, 2011. It was granted by the judge March 21st. And the response...
And it was a 30-day or so. It was... I have it in my notes, but anyway, it was for a block of time around the time of the crime.
It was from December.
What was the time requested, from when to when?
From December 1st 2011, the crime was December 16th.
Right.
To March 15th, 2011.
Right, December 1st, 2010.
And the
right.
response from
And
T-Mobile.
he was on the run, right? They couldn't find him.
Right.
So what's wrong with that?
Because it's, and if I could just, the response from T-Mobile wasn't until April 27th, 2011, so it was over a month later. So if you're looking to apprehend him currently, looking at historical cell site location information is not going to cut it. And so if what you want is probable cause to believe where he is now to apprehend him, this was not the way to do it. The way to do it was to get prospective GPS tracking, which this court has said, requires probable cause, and which the statute says is only good for 15 days. So that it cannot be used as an excuse.
Which case
Which
did we-
statute are you referring to? I'm sorry.
Oh, brother,
That's okay. Is it a federal or state statute?
It's in my brief. It may be the case law. I think it's Connolly. Is it Connolly?
Oh, I thought you said a statute.
Oh,
Connolly for GPS said you can do it for up to 15 days. That's what you're referring to.
Oh, okay.
yeah.
But that, yeah, okay. But have we ever said for CSLI you're limited to 15 days?
Excuse me?
I don't think Augustine or Estabrook or anyone say that the Commonwealth is limited to 15 days, have we?
For
July?
the probable cause for prospective GPS is limited to 15 days.
In which case, for GPS in Connolly,
yeah.
but have we ever said
Yeah.
that with regard to CSLI?
No, but historical CSLI can't be used, certainly 3.5 months or 3 months, because it's 3 months from the crime to the end of the CSLI that the court said was what was used for the apprehension.
Aren't we supposed to judge probable cause by the time the police make an entry or request something? And if T-Mobile is a month late, why should we hold that on against the police?
Well, because the request was 2 days after they asked for the end of the CSLI. They asked for CSLI up to March 15th, and they requested it on March 17th. So already it's pretty stale if what you want to do is know where he is right then.
So you're saying you can never get CSLI? You always have to ask for prospective information because the person isn't where he was?
I'm not saying you never can, but when you look at how accurate or inaccurate CSLI is compared to GPS, there's a certain number of yards in which you know where the person is, so you could tell what building, perhaps what floor.
Shouldn't we defer to the people that catch criminals?
Oh.
We're making these that you can only do this. So if they got the CSLI and it showed the person was in New Bedford, not in Boston, that might be information a police officer would want to catch someone, right?
Well, the whole point of the right to suppress evidence under the Fourth Amendment is because we don't give a whole lot of discretion to the police. We might give them discretion about what they know on how to investigate, but when it comes to a police officer saying, I need 3.5 months of cell site location information so I can find out where the defendant is now, we don't have to give any discretion to that because it's unreasonable.
Does
And in fact, the affidavit never asked for the CSLI in order to apprehend him currently. It's just something that the motion judge included in his reasoning for why he was going to uphold the CSLI.
It wasn't an affidavit, it was an order, right?
Well,
It was a D order affidavit, right?
It
wasn't a search warrant, it was.
It was an affidavit. It wasn't a search warrant because it was done before.
Right, yeah, it was done-
before Augustine, so it was
right.
just the affidavit that goes along with the 2703, and so so it was an affidavit, and he included the words of the statute, which includes and apprehend the defendant. It would give information for.
Does any of this matter? I mean,
Well,
the key information is was he present at the time and place of the murder, and there's clearly probable cause for that time period. So is all of this irrelevant?
Well, the irrelevant, are you saying irrelevant because of the evidence at trial, so it
Well,
wasn't
the
prejudicial?
only
or-
evidence that's meaningful is that the phone is in the location of the murder, right? And do we, if it was too broad a request, does it matter?
Yes, it does
Why
because.
does it matter, and which cases say it matters?
Okay, it says it matters because there was no probable cause for the period outside the time of the crime, and the Fourth Amendment violation occurs at the time of the seizure of the 3.5 months of cell site location information without probable cause. So the violation already occurred at the time the Commonwealth seized his confidential information, which is 3.5 months of cell site location information. So,
Which case says we can't carve out the legitimate from the illegitimate?
well, this court said it in Estabrook.
I read Estabrook. I find it hard to figure out exactly what Estabrook said on that.
Well, it cites, well, the federal law is clear, because this is also under, it's also under Fourth Amendment argument, but the federal law, that's Balsas, and there's Calandra, and then there's Vendora hyphen something, where the courts specifically say, including the U.S. Supreme Court specifically says, that the Fourth Amendment violation is complete at the time of the seizure. And it contrasts it with the Fifth Amendment violation, which occurs at the time of trial. So the violation already occurred even before the trial began. So it doesn't matter if there was just, say, 6 hours of probable cause, and that's all the Commonwealth admitted at trial. That doesn't solve the problem of the previous Fourth Amendment violation, because the violation already occurred.
But in Estabrook, there was no probable cause at all. Here, there is probable cause, but it's arguably overbroad in its duration.
But it's not the facts of Estabrook that are in Hobbs's favor. It's the law in Estabrook.
Right, but if you go back to Estabrook, you'll see that there was not probable cause for any CSLI. Here, there was probable cause for some CSLI, but you claim it's overbroad. So tell me what the appropriate period of time would have been that would not be overbroad.
Well, if what the Commonwealth argued at closing is the day of the crime. And so what it argued was, we see that he used the cell site near where he lives in Roslindale in the morning. We see that around the 2-hour period before the crime, he's hitting off the cell towers around the crime scene within a half mile. And then after the...
Or they know this. So my question to you is, in their application, what would have been an appropriate amount of time supported by probable cause for a killing that occurred on December 1?
Well, I would say December 1 would be very safe, especially if what you want to know is if you want to track the person. They knew where he had lived. They knew where the crime occurred. So if what they wanted to do was to be able to track him from where he lived to the crime and back, you would certainly believe that there's probable cause to believe that the full day of December 16th would give you that.
December 1, you mean? I'm sorry,
Well, the
December
crime
16th.
occurred on
December 16th, I'm sorry.
Yeah.
So you're saying one day.
One day clearly would be probable cause.
What would be, well, I'm
But
not
they
asking
don't-
what clearly is. I'm saying if they had said 12:15 to 12:17, is that overbroad?
If there was reason to believe, what they had was the belief that there was one person who committed this crime. If what you thought that there were co-conspirators and you wanted to know if someone was ever near the co-conspirators, if the co-conspirators and the person you knew committed the crime were ever in the same place at the same time or then you might want,
Okay, try my question.
okay.
12:15 to 12:17, overbroad?
If all that, yes, if all that the court had was the facts in the affidavit as it was presented to her, then I'd say yes, it was overbroad.
So you're saying if you find any overbreadth for a day too long, then you say that the whole thing gets wiped out, that the whole thing is suppressed?
Right.
Have we ever said that? Isn't it sort of hard to figure out what the appropriate duration is?
Well, if there's no reason to believe that 3 days' worth of cell site location information is necessary, then there's no probable cause for it. And what you have is what even the U.S. Supreme Court had said in Carpenter is that the way you can detail where people go through cell site location information now with the number of sites that they have, you can actually track them fairly closely, and you can know where they go, what private organizations they belong to. And so, yes, I would say that unless there's probable cause to believe that the day before and the day after are necessary, if all you want is was he at the crime scene at the time, then, yeah, it is.
And those cases you cite, Balsas, Calandra, Dora hyphen something.
Yeah.
They say that if you are 1 minute overbroad.
No.
So has any federal court ever addressed that particular issue, that if you're slightly overbroad but you're not using any of the information from the overbroad period of time, that we suppress the evidence?
Well, everything in the law is based on reasonableness. So if it's reasonable or not unreasonable for the affiant to perhaps go, a half a day before and a half a day after, then I don't see that defeats the whole holding of the law, which is that you can't admit any CSLI if there isn't probable cause for all of it. So, I guess you could think of a scenario that seems ridiculous, but since the law is based on reasonableness, I think that any court would say, well, we're not going to go back in time and rewrite what the affidavit should have said. It was reasonable, even though ultimately when we got the CSLI, it wasn't necessary. So I think that certainly how the courts have handled affidavits, they haven't been absurdly strict with what the police officers have written in them.
Now, the Commonwealth argues that this doesn't matter in the end because there's plenty of other evidence. Do you agree with that?
No, I don't, because I believe the Commonwealth overstated what the testimony was about identification. None of the people who looked at the shooter after they heard the shots and looked out their window was able to identify Keith Hobbs.
We have two witnesses who identified him from the video, right? One through the grand jury testimony, the brother, and the other, this person who was had a relationship with his friend.
Right. So what we had the people at the scene who identified clothing, and we had his brother who retracted his identification at trial, and we had the questionable.
Yeah, Ms. Robinson, right?
Right. Roseanne Robinson, who was the wife of someone who was tangentially all related to this, and that the Commonwealth thought was going to be testifying, but did not. And she not only had a reason to identify Hobbs as the person in the video, because she wanted to take away suspicion for her husband, but the husband himself had a coat like the person in the video, had the gun that sounded like the gun that, was the same type of gun that was used in the killing. He was also known to use Keith Hobbs's phone. He was a known drug dealer. That testimony came in. We also have really the only eyewitness, who was Jessica Taylor. She saw the person who threw the gun in the dumpster, walked by, she saw a child outside, and she was brave enough to go outside and take that child, and the shooter passed her. She looked at his face, never identified him in the photo lineup, even though he was in it. She identified someone else in the photo lineup and said she was 90% sure it was him. And at trial, she had said, if I saw him, I'm sure I would recognize him. And when she was pointed out Keith Hobbs at trial, she said she never saw him before. So it was not a strong case. And the court has the video. It's a very grainy video. And the video, as the expert had said, for television video, there's
Can I ask you about that, about your claim of prosecutorial misconduct? When the defense expert set up this program, the label on the program was book and photo. Was that shown to the jury?
No, all along it was going to be redacted throughout the trial. That mentioned a couple of times that it was going to be redacted.
Right, but
Was it
the
redacted?
was it redacted? I guess, yeah. Was it redacted?
Well, I didn't go back and reread when it went to the jury. My understanding was it was redacted. That was the whole point.
But it was the defense expert is the one that puts in the reference book and photo.
The defense expert doesn't say.
What he, and maybe your sister can tell us about this, but the defense expert has an exhibit that compares a photograph of the defendant to the video.
Right.
That's played to the jury.
Right.
But
And that was going to be redacted before it went to the jury.
All right, so that part where it flashed book and photo was not shown to the jury, or was?
Well, you're asking me a question I never researched myself. They talked about redacting it.
But you accuse somebody of prosecutorial misconduct.
Right, because.
And you probably should know that, whether that was played to the jury, don't you think?
Well, no, because what was talked about a number of times, and it was cited to in the record, is that it was going to be redacted. It was pointed out that it says booking photo, and the defense attorney said, yes, that's going to be redacted before it goes back to the jury, as is almost always the case in trials where something is going to be redacted before it goes back to the jury. So it was understood. So, and when the judge said, oh, that's not how it's depicted, enough about that, then the prosecutor says, but I'm just reading what it says underneath. So I think that it was more than just carelessness.
So is there any indication that this booking photo came from a booking other than his booking at the time of arrest in this case?
No.
So doesn't the jury know that he was booked
Well,
for them?
actually what we have is we know that the photo that was admitted, the actual photo that was admitted was described as something that was taken at an, oh no, that's not, no, that's wrong. That's another photo from Facebook.
I mean, the jury knows he's standing before them for trial. Why is it prejudicial for the jury to believe that he was booked on those charges?
Well, I just think that it's something that should have been raised because it was something that it was only, a big thing wasn't made of it only because the trial attorney intentionally didn't object because he didn't want to bring any more focus on it, and because even he knew it was something that shouldn't have been said.
Can I ask briefly about the police officer testifying about the defendant's distinctive gait? Was there anyone else who was able to test or who testified at trial about his distinctive gait?
Roseanne Robinson testified at trial about his gait. She said, well, he wasn't pigeon-toed, but she couldn't quite say. He was a little bow-legged, but he wasn't really bow-legged. She can't describe it. She just said it was an odd walk. But this court has the videos, and if you look at the other people in the video, because of the stop action nature of these videos, and it was a pretty primitive video, they all look like they're walking weird. And so I think that isn't really something that takes away from the prejudice of what Bliss said, because I think when you look at the video, it is so grainy, and everyone looks like they're walking weird.
Not that grainy. I mean, parts of the video are pretty clear. I watched it this morning. It's not all grainy. I mean, you can't see his face in the video, but you see him quite clearly. Do people identify, do the eyewitnesses look at the video and identify this person as the person who did the shooting?
Really from the clothing,
but
Yeah, a couple of them did. They, through clothing, they said that was the person who they saw walk away or dump the gun in
The videos gives you clear pictures of the person. Whether you can identify the gait, I think, is trickier.
Well, I didn't,
but-
I thought that it was almost impossible to tell whether he was balding in the middle, which
I
Bliss said.
agree with that, too.
Or that he had red sneakers on.
That I wasn't paying attention.
Yeah, so
A lot of video of this person. I mean, an enormous amount of video, some of it very close up. You just don't see his face.
right, I mean, the closer up doesn't really accomplish much. It just seems to get more blurry the closer up it gets, so
But that was an issue though, right? Because some of his witnesses testify he didn't have a gait, he didn't have a limp.
right.
And then the Commonwealth argued through these other witnesses, so.
And his girlfriend of 2 to 3 years said that she saw it dozens of times and she couldn't say that it was him. And even,
So it was a disputed issue whether or not he walked with a limp.
right, and even the brother said that he saw it about 40 times before he thought it was him.
So the trial judge kind of did a compromise, right? Because
She did a compromise.
the government wanted to put the video in to allow the jury to look at them.
Right.
She was concerned appropriately about the prejudice, so she kind of cut the baby in half.
Right, and you know, one of the problems is Bliss's testimony was so exact, and also he was so much a part of this whole, he was the lead detective, he testified about cell site location information, the hours of the calls, where this cell
But
sites were.
if she had allowed the video in, the jury could have made this determination themselves.
Well, of course, it was late, so then you get to the other issues.
Right.
Yeah, okay,
Okay, thank you.
thank you.
Ms. Campbell? Good morning.
Good morning. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. With me today is Montez Haywood, who is one of the trial prosecutors in this case. We ask you today to affirm the defendant's conviction for the first-degree murder of Demetrius Blocker. I'll start wherever the court wants to. I think the fastest way to do it is to speak first about the expert label, because I want to make some clarifications.
I'd like you to start with the 30 days. I find that really complicated, the law on that. Could
The
you-
law on the
Whether.
on the motion to suppress?
Particularly the question whether, if there's clearly probable cause for the critical evidence is he there at the murder? And there's
Correct.
probable cause to get that information, but we have a very long period of time here. If that's too broad, what does the law say about all that?
So the law currently, the only case, at least in Massachusetts, that deals with what you do when there isn't probable cause. So to answer your question directly, there is no overbreath case. Mm-hmm. The only case that comes close to approximating the answer to that question is Estabrook, and I agree with Your Honor that Estabrook is confusing, because if you look at what it says, it simply says that it would violate the constitutional principles underlying our decision in Augustine to permit the Commonwealth to request and obtain 2 weeks or longer of CSLI so long as the Commonwealth seeks to use evidence relating to only 6 hours. So it's not quite exact, and they don't carve out the part that isn't a constitutional violation, because they said that it would undermine the rule in Augustine. I disagree with my sister that any federal cases provide any light as to the issue, because federally there's the good faith exception. So they never get to this question typically, because they say the officers were relying upon a statute, or the officers believed that they were doing the right thing, therefore the exclusionary rule shouldn't apply. If you want to go that way, I'll be okay with that, because I argue in almost every single brief that that Massachusetts should.
And you argued it in this brief.
I argue it in this
Yes.
brief too. I will continue to argue it over and over again.
And I will continue to read it.
It's good to dream.
A triumph of hope over experience, but go ahead.
Correct. So I don't think that federal law provides any clear guidance on the issue, because they found another way to deal with it. That being said, what I think the court should do is what I say and what I argue in my brief is that you should carve out what isn't a constitutional violation and let the rest fall to the wayside. If the court doesn't want to reach that issue, I don't think.
Are there any analogies that we can look to that will help us on that? For example, overbroad search warrants that ask for multiple locations or different types of property, and part of there's probable cause for, and part there isn't. Anything we can look to analogize?
I'll have to provide a 16L letter, because I can't find in my head, I can't think of the name of the case, but there is a case in which it's a murder investigation. They go to both a house and a storage locker. The storage locker, they find that it's overbroad as to the storage locker, but they don't get rid of the PC for the house. I don't think that that's quite an exact...
That's a Massachusetts case,
It
you say?
is.
Okay.
And I'll find it and provide it in a 16L letter. I don't really think that that's an exact analogy, though, and it's hard. I've said this before, too. It's hard to fit CSLI because it's a record squarely into constitutional principles because it's not quite the same thing. I think it should be like when there's a defect in a search warrant for, let's say, a house. You don't necessarily toss out everything that was seized via that search warrant because there's one infirmity in the search warrant. So a good
But
example.
those are different kinds of infirmities that you're talking about. Usually those are more, you've got a number wrong or the floor wrong or something like that.
There could be that. There could be infirmities as to you didn't prove that there was necessarily a nexus as to part of what you're seeking and not the other,
All
because it really comes down to a nexus problem, I guess, when you're talking about overbreadth. I don't think that that's a problem here because here, I think it falls under that second prong of the Augustine probable cause standard, which is there's probable cause to believe it will aid in apprehension of the defendant. Because as my sister eloquently stated to this panel, CSLI does reveal the patterns of an individual's life. So if they commit a crime and they're at large, and I think a key critical fact here too is that this is an individual who wasn't known to have a steady address, and his family had been trying to contact him during this period of time and could not. So the CSLI could shed light as to the patterns of his everyday life where the police should be looking, whether that should be in Boston or whether it reveals that he's somewhere else.
Is there any validity to the argument? Well, they asked for it in March, and they didn't get it till April. So
No, because we don't control when the cell service company provides it to us. I also don't think...
But under D orders, you can get, as you well know, exigency issues, right?
You could.
And they didn't look... It seems like this is bootstrapping.
I don't believe so, just because the police didn't pursue one avenue of investigation as opposed to another. And when they applied for it, there was no reason to believe that T-Mobile or whatever service provider it was wouldn't provide it to them in an expeditious manner.
Does that mean whenever we've got someone on the lam, you get unlimited CSLI for them because it may help figure out where they are for indefinite periods of time?
No.
Okay, so why not?
Why not? Here, there are the limiting factors in that they ask for it up to the point that the affidavit is written for the D order. But more than that, you have characteristics of the defendant that make it so having this type of pattern type information would be useful in that he doesn't have a known address. And his family has been trying to contact him during this time and has been unable to.
But people on the run tend to not go to their regular spots. So wouldn't it always be useful to find where they're at for long periods of time, figure out all their safe houses?
Sure.
So, but that means forever. I just don't see a limitation on this.
I think the limitation is as long, I think, there's a proximity to the crime and then the part where they're still on the run.
But as long as they're on the run, you can get like months and months, right?
Again, that's a nexus question that would have to be presented to.
Your sister says, well, there's another way of doing this, I guess, pinging the phone to find out where they are, so you don't really need any CSLI.
And again, my answer, and I don't want to be repeating myself, is just because the police didn't pursue one avenue of that investigation doesn't mean that the avenue that they did pursue was constitutionally invalid. I think, though, part of this comes down to the problem in that this affidavit was authored in 2011, which was years before Augustine came out. So to the extent that there are infirmities in this affidavit or that fault is being placed for the officers not using specific language, they weren't on notice that they had to use this language.
Then you're back to good faith? Or how does that play out in our analysis as opposed to the federal analysis?
Well, I think it does bring me ultimately back to good faith, but it does bring to the constitutional principle that exclusion is a remedy, right. Though it is a remedy.
So let's go back to good faith for a minute. In Massachusetts, what's the basis for the rejection of the good faith exception?
It just says Massachusetts courts have not accepted the good faith exception.
So it wasn't specifically grounded in any particular article of the Constitution?
Not that I could find. Not that I could find, and not that
There was nobody did an analysis saying this is where the Massachusetts Constitution departs from the U.S. Constitution because of XYZ?
No.
So it's just here.
It's just we have declined to adopt it. And I don't think that makes sense because Article 14, just like the Fourth Amendment, is a reasonableness test. And so I don't understand why you wouldn't, when assessing whether an officer's behavior is reasonable, look at the existing law at the time. And what the officers did here at the time was they did what a statute told them to do. There was no case in 2011 in Massachusetts or federally that said that they needed to get a search warrant. So now, 7 years later, to look at this affidavit and to apply a retroactive law that the police are now tasked with being clairvoyant when they were writing this affidavit, I think is fundamentally unfair, and it doesn't go to what the purpose of the exclusionary rule is, which is to deter police misconduct. I think that this can be distinguished from a lot of different cases in that it's not a case where the police just show up at a house without a warrant and search it. They did apply under an order with an affidavit that's just very similar to a search warrant affidavit to obtain this data. And they did it pursuant to the statutes in the case and the law that was existing at this time. I also think that, it hasn't been a problem with cases that have come down post-Augustine, so 2014 forward, because we've had a clear law as to what you need to do to get this type of information. The problem is, especially in first-degree murder cases, they linger for such a long time that we're now 7 years after this affidavit was applied for, 8 years after this murder was committed. We're now tasking the officers with the development of 8 years of case law. And I don't...
8 years of technology.
8 years of technology. And I can't find anywhere, when I trace very back to, why the exclusionary rule should apply at all, that would say that that is in any way a type of just or fair or equitable remedy that should apply. Regardless, it doesn't matter in this case because of the evidence that was introduced.
I was going to say, you're biting off more than I think
Well, some
you
of
need
us
to.
might be interested in hearing this.
Maybe. So, the person knew they had to do reasonable, under the existing law at the time, they knew they had to do a reasonable basis, and what they provided was, in fact, PC. And now we have the issue of the duration, which, of course, would have had to be relevant even under the old law.
Correct.
So,
Which I believe it is.
and you argue that it is an appropriate duration.
Correct. Because of that apprehension language, which they didn't know at the time that they authored the affidavit, but we'll put that aside. Either way, the introduction of this evidence was harmless beyond a reasonable doubt because of...
Yeah, that's an even harder argument. When you have all... this would add the fact that his phone was in or around the area.
It does.
That's a major addition above and beyond that the person seems to have a gait similar to the defendant.
I disagree. I think that's an understatement of what the evidence was, because what you have is 5 eyewitnesses in this case. 4 look at the surveillance video of the individual leaving the scene of the murder, and 4 of them identify that as the person that they saw as the shooter.
Those 4 don't identify him.
They don't.
Right.
They don't because...
You have 2 people who identify him.
Correct. His brother.
His brother and Ms. Robinson.
Correct. Correct.
So the other 4 are, will give you the video of him, but they, and you have this Taylor person who doesn't identify him.
She doesn't. I think it's important there, though, that she is the one that's dealing with a young girl that's outside. Her attention is focused elsewhere, I think.
But I think it's a bit of a stretch to say it's a strong ID case.
I think it is a strong ID case. I think when you look at the identifications that are made, I think they are strong. And I think it's strong when you're looking at a surveillance video that what even tells the officers that this is the person that they should be focused on is his own brother calling and saying, I saw my brother on TV.
But he recants, right?
He does.
And he has reason to recant, meaning he's got incentive to recant. It's his
Absolutely.
brother. But the other person, is Ms. Robinson's husband, does he look like this guy? Do we know what he looks like?
Yeah, and there's evidence at trial that is admitted what he looks like. He is significantly larger than the defendant. He's about 350 pounds and much taller. The defendant is...
So he's 350 pounds?
Correct.
How heavy is the defendant?
That's in the trial transcript, too. Off the top of my head, I don't remember, but he's a much smaller individual.
So the video is hard to the video is hard to get a sense of size, although you don't think he's 350 pounds, that's for sure.
He definitely isn't, and there's evidence that he definitely isn't, and there's evidence as to the distinguishing factors between the two. And it comes out on the redirect of Roseanne Robinson.
So is that, you're saying that Ms. Robinson's doesn't really have to get rid of, she doesn't have to work very hard to get her husband out of the picture because he doesn't look anything like the person?
Correct.
Right.
Correct.
Okay.
And not only that, the way that she identifies the defendant via his clothing is that much of that clothing had belonged to her husband, and her husband gave it to the defendant.
Can I ask about a couple of the other errors? I don't understand the basis. The adoptive admission, it's why is that an adoptive admission? It's pretty cryptic. What he just says, so what, or something, what is it, whatever, or something? That's not really like an adopted admission, is it? When you say whatever?
Well, whatever he says is non-hearsay because he's a party opponent.
I know, but you're saying that it's an adoptive admission of what the other person said.
The adoptive,
I don't understand how saying whatever is saying I agree or admitting.
Well, he says nothing. He's silent as to the part where his Bonet Swain Price is saying, and your sister called and said that she saw you and that you were the person that committed this murder too. He says nothing. So it's when someone, the adoptive admission principle.
The adoptive admission here is to the statement in response to the whatever, when he says whatever, right?
I don't believe so. I think the adoptive admission goes to the conversation that Roseanne Robinson overheard, which is.
So I had a conversation with my sister, that's
Yes.
fine.
Correct.
And then the second part is hearsay.
Which the judge
Well,
does.
kind of.
Sustains and says, you
Well, the
shouldn't
judge doesn't
rely on
really
that.
strike it. The judge just says, don't do that, or says something like, ladies and gentlemen, the jury, there's this thing called hearsay, but doesn't really address that statement.
She says it's unreliable.
It doesn't say what's unreliable.
She says hearsay is unreliable. I agree, it's not the best sort of curative instruction or sustaining, but I don't think it matters anyway, because I think when someone is saying to you, oh, my sister says that she saw me on, your sister said that she saw you on TV too in connection with this murder, the adoptive admission looks and says, if you're silent in the face of something that you would normally respond to.
Couldn't whatever be, whatever, that's ridiculous. Or,
Well, whatever is a different
Yeah, that's a different
conversation.
Which one?
Sorry, okay.
When did he say whatever?
So
That's the confusion.
He says whatever. He comes home. Roseanne Robinson says, I saw you on TV. He says EI, which she testifies means whatever. She then.
So that's when Roseanne Robinson said, I saw you on TV.
Yes.
It's not when he said, my sister said she saw me on TV.
Correct. That's a different conversation.
So you want him to say, my sister is wrong, and that if he does not say, my sister is wrong, that it's an adoptive admission?
Yes, or something to that effect. He is adopting what his sister said, which is, I'm the person that's wanted in connection with this murder.
It's attenuated because it's not the conversation with the sister. Now it's the conversation with somebody else about what the sister said.
Correct? Is it the cleanest sort of hearsay type of argument? No, not by any means. Do I think that it rises to an error? No. Ultimately,
Question really is whether it's prejudicial.
correct, and I don't think that it is.
I think that's
It was
what we need-
fleeting.
I think that's what you need to focus on.
Sure, I'll focus on that. It was fleeting. The judge does tell the jury that it's unreliable and that they shouldn't rely on hearsay. While that's not the most clear sort of curative instruction, it is there. And it's not mentioned by the prosecutor in closing argument at all.
Can you do, sorry, are you done with that one?
I'm sorry.
So the other one I don't.
Before we leave that point,
Yeah.
I'll get back to Justice Kafker. Did his sister testify?
His sister Nicole did testify.
She did testify.
Correct.
And,
Hold on one.
I'm sorry?
I know a sister did testify. Let me check and see if it was that sister.
Oh, I see, okay. 'Cause
Yep,
it's-
Nicole Hobbs did testify.
And did she testify that she identified him as the defendant? I'm sorry, as the person in the video? You may want to look to your brother.
I am
don't
looking
know.
right
Maybe-
here.
Maybe your brother knows?
No, she did not.
Right, because you only had two people identified from the video.
Correct. Correct.
So
The
she
brother
would-
recanted and Ms. Robinson.
So she was on the stand, but she did not say that I saw TV and I saw my brother on TV.
Correct.
But that came in through his state, or through Ms. Robinson saying that the defendant told me that my sister said she saw me on TV.
Correct.
And who testified first, Ms. Robinson or the sister at issue?
Miss Robinson.
So when the sister testified, all sides knew that Robinson had said that this sister had told the defendant that she saw him on TV.
Correct. Correct.
So which means there was an opportunity for cross-examination of the sister on that.
There was. And as to the specific cross-examination, I don't have it in my notes that question was asked. I don't have a clear memory.
And does that fit it into the ID hearsay exception, if she was available to be cross-examined on that? I've got to go back to that, but
It might. I hadn't thought about it that way, obviously, because I didn't argue it in my brief.
I'll invite you to do so,
Sure.
and both sides can address that if you wish to in a post-hearing letter. And I interrupted Justice Kafker, so we'll get back to his question.
I was just, there's so many issues. So the gate, the officer, they videotape him in prison.
Correct.
They see his gait. Then the officer is testifying about his gait. I will defer to my colleagues who are trial judges, but this seems odd to me. The jury doesn't get to see that. The judge doesn't let the jury see the video from prison.
Correct.
We have him commenting on it's the same gait, and the jury is not seeing the gait. The jury is in just as good a position as he is, because he's not at the prison. Isn't that an error?
No,
Really?
I don't believe it is.
I just don't get how, tell me how that gets in.
Sure.
He gets to testify about a video that only he has seen, saying it looks like the same guy, and it's not even something that he has any special expertise that a normal person wouldn't have. So tell me how that gets in.
So it gets in, first of all, there's case law which says that an officer can testify about things that they see on a video. So I would point to that case law. It's an appeals court case that I cite in my brief. And then I cite other cases from other jurisdictions that specifically talk about videos depicting someone's gait. So I'd say that there is precedent to support that this type of testimony is admissible.
What about the next step, though? That's problematic.
The comparison?
Yeah.
I don't think that it's a problem under the case law that my sister cites, because that is the identification of the
But that's
person as the
police and all
perpetrator.
those other
Correct.
cases. But what gives him the ability, I get that he could say, I saw a video, and in this video, it was of the defendant, and it was taken at such and such a time, and he limps.
Yeah.
But it's the next step that's problematic.
I think it's
Oh, and by the way, it's the same limp as the guy on the...
Yeah, and I think too, why that's okay is that it's important always, identification is at issue, and the defendant does in his closing argument attack how the police dealt with the surveillance video itself, which depicts the limp. So I think it's important for the investigating officer to talk about the characteristics and the reasons why the defendant was focused on this specific defendant, why they believe that he was the person that committed this crime. It goes entirely to the police investigation that led them to the
Are you
identification
saying
of the
it's a
defendant.
Bowden issue?
I think it's, yes, because of the way that the defendant argued it in this case. I think that an officer should almost always be able to detail why the investigative steps that they took that led to the identification of the defendant, because identification is always a critical issue at trial. I'm happy to answer any other questions that the panel has.
Before you leave, let me
Sure.
just, in terms of our 33E obligations, so I'm sure we'll look to your brother's closing argument, but ultimately what you have here is you've got the ID from the brother based on the video. You've got the ID from Roseanne Robinson. You've got the CSLI, assuming you keep that.
Yep.
Is that about it?
No. You have 5 eyewitnesses that give descriptive characteristics which match the defendant. Not only that, 4 of those 5 look at the surveillance video and identify that person as the shooter.
Okay, so there's no doubt that this person in the surveillance video is the shooter. I
Correct.
accept that.
Correct.
But
But
now the question is, was that shooter the defendant?
Yes, and I think it's enough. I think that What is important here is the testimony of those 5 eyewitnesses and the descriptions that they give, because the jury was able to look at that as circumstantial identification evidence and come to the conclusion that they were describing the defendant himself.
But the one person who was the most close does not identify him in a photo spread.
She does not. But I think if you look at her testimony specifically about where her focus was, and you look at identification evidence sort of principles generally, that isn't as alarming as it seems at first glance.
Okay, and I gather from the briefs just that no one is intimating that she failed to identify him out of fear.
There is no evidence of that. I think her testimony largely was that she heard this shooting, she saw this young child sort of out in the middle of it. She was really ushering the child back in.
He was focused on moving the child out of the way.
Correct.
But she gives like a 90% certainty identification to the wrong person.
She does.
Yeah.
I think it shows the limitations of eyewitness identification evidence, but that doesn't mean that the evidence that we have is insufficient to support the verdict that came down.
I'm not arguing, the issue is not really insufficiency,
Oh,
clearly.
I understand that. I just don't want to undercut what I believe the evidence shows. And
Okay,
thank you.